Only mode.
Hello. Good morning, everyone. Welcome to IP Metrics webinar series organized by IP Metrics Consulting Group. Today's webinar topic is developing a strong patent portfolio. Kindly note all attendees who have questions in any questions in between, I request you to hold on till the end of the session. We'll have a separate section wherein we answer all your questions and queries. If you have any other doubt, you can raise your hand so that we'll attend to you. Right now, let me introduce to the speakers. Speaker Arun K. Narsani, founder and CEO of IP Metrics Consulting Group, and Senthil Kumar, lead patent analyst and a research executive from IP Metrics Consulting Group. Over to you, Arun.
All right, yeah. Thanks a lot, Akshita. So first of all, I'd like to welcome you all, and thanks for taking your time, valuable time during the day. I can understand it can be tough to find time out of schedule. Akshita, can you take to the next slide, please? Next one. Yeah. So this has been a pretty good start to the webinar series. This is our third webinar. First one and second one were very successful, and we got very good feedback. And we've been using your participants' feedback to develop more useful content. Brief about us before I dig into the topic. I'm the founder at IP Metrics Consulting Group. I've been in the IP field for close to 10 years now. Before that, I was a software engineer. I've been a patent agent for a long time, and I've been doing patent prosecution and portfolio management all this while. That's a brief about me. And then next slide, please, Akshita. My colleague Senthil will also be presenting today. He heads one of our research teams. He has vast experience in conducting different kinds of searches, including novelty, patentability, infringement, validity, landscape, and so on and so forth. He brings in deep expertise in this particular area. So next slide, please, Akshita. So we will be dividing this into two parts. Today we're going to be talking about how to ensure that whatever portfolio that we are developing is a strong portfolio. A lot of times we hear that 99% of patents are not really useful, and that they're just merely incremental and not much of value. It's all true. Probably 0.5% of all patents that are ever filed actually make some money, probably a little more money than what it costs to get the patent itself. Even less percentage of patents actually are what are called successful patents. So given this context, it's a pertinent topic to discuss about how to ensure that as a company or as a person within an IP department, or even as a person supporting an IP department from an external outfit, how do we ensure that whatever patents that are being filed are reviewed thoroughly to ensure the quality of patent? There are many steps that you can take to review and then make an informed choice on whether to go ahead with the filing of a patent or not. So broadly, that is the scheme or the theme of this topic. We will be splitting this into two parts. One is pre-grant part, where we talk about aspects before filing a patent application, and then another is a post-grant, before grant of an application. Another is post-grant process. So once you have a patent, what do you do to ensure that you eliminate waste and then ensure that you put the patents that are useful to actual use? So these are the two parts. I will be addressing the first part. My colleague Senthil will be addressing the second part. The first part is pre-grant essentials. When I say essential, it means what exactly are the things that you need to focus on to make that informed decision on whether to whether a particular patent application is going to result in a useful patent, and therefore whether you should go ahead and file it or not. So in that context, I just want to kind of briefly note that we're not going to explain very basics of what a patent is and so on in this. We're assuming that people who come to this webinar already know what a patent is and so on. So this is more at a higher level. Next slide, please. Okay, so so one of the basic things just to get things started is the element of a patent that is crucial in terms of defining the invention. The goal of a patent application is to define the scope of the invention, and the way the system works is an inventor claims an invention in through a patent application. So obviously there's a section called claims, and claims is the section that is basically the heart of a patent document. I'm sure a lot of people, most of you will know that. Now, given that claims are the ones that define the invention, so what is the role of the entire document, which is, typically tends to range from, maybe 40 pages to sometimes even 100, sometimes even, many hundreds of pages. So the description and drawings basically are intended to support the claims. So when I claim that, hey, this is an invention that I came up with and I deserve a patent, the immediate question is, prove it to me that, you actually deserve a patent and that you actually can do it. So description part, takes care of that by describing the entire invention and in support, supported by a drawing section. So that's a very, very 30,000 feet high-level view of what a patent is. So obviously the crux of the matter is claims. We're going to talk about a little bit more. So that is why this introduction. Next slide, please, Akshita. Now, so that given that there is an element, what exactly will get you a patent? So to actually get a patent application granted, there are a few requirements that need to be met, and two of the most important requirements are, one is novelty and the second one is inventive step. Novelty is an invention is said to be novel when it is not anticipated or when it is not captured by any one reference that existed before the application of the patent. Inventive step is basically a technical advancement. An invention has to show a technical advancement, and that advancement should not be obvious given the existing state of the technology. So these are the two basic requirements that need to be met. So in order to meet these requirements, we already said that claims are the one that defines the boundary of the invention. The claims need to be written in a manner that they show some novelty and that they should not be obvious. All right. Next slide, please. So given that these are the requirements and that claims define it, the goal typically is everybody. I mean, it's human nature to be greedy. So the goal typically is to claim the invention in the broadest manner possible. Right? The broader the invention that we claim, the more is the scope of monopoly over that particular area. So the typical tendency is to claim the invention in the broadest manner possible and claim as much of the invention as possible. There may be many aspects of an invention. For example, a device could have many methods that are going on. So you're talking about methods, you're talking about devices. Sometimes when there are discrete parts, you're talking about capturing systems. So depending on the commercial angle of that particular product or process, we need to look at look at claiming all possible variations of the invention in terms of how it is actually transacted in the market. So these are the three basic essentials of a patent document and what we all try to achieve in trying to file and get a patent granted. Next slide, please. Okay, so now we're going into a much higher gear. So basics aside, so what we are trying to understand here is a basic workflow of examination procedure. This will give us an idea of what we need to do to ensure that we don't fall into the pitfalls that make our patents weak. Many times it's not just invention. Sometimes its invention is weak. I mean, it's only incremental. There's nothing much that can be done. And it's a strategic choice that companies make as to why that patent needs to be filed or why it need not be filed. For large companies, for example, they may have thousands of patents, and for them it's not really about quality of patent. They just need a few thousand more maybe to do cross-license with another company in case there is a matter of litigation, or in case there is a dispute. For such companies, maybe they may file a lot of incremental patents. They still find them valuable. But for most companies, two things are essential in ensuring that a strong patent is obtained. One, the invention itself. So the company or the inventor needs to make a critical review of how strong that invention itself is, first of all, because it's a very time-consuming process to get a patent, and it's very costly to get a patent. So that's one thing, to ensure that invention itself is strong given the existing prior art. Second is, there are a lot of procedural aspects that inventors or applicants are not aware of, and therefore they make choices that are detrimental to the quality of the patent ultimately that is issued. So that is the thing that I'm going to highlight here as to what are the things procedurally that you need to look at to ensure that you don't go down a lane where patent is getting too narrow, or the claims are defined in a manner where it's not useful anymore. So to be able to get there, to talk about that, we need to understand the basic workflow of a patent prosecution, which is similar whether it's in India or in US or any other similar nation in a jurisdiction. So it starts with filing of application. Examiner reviews the application when it's time. If the examiner is satisfied that the requirements are met, then he will grant it. If the examiner is not satisfied, then he will issue what is called as an examination report or an office action. Once the office action is received, the applicant or the inventor or the company can initiate a hearing procedure. Maybe the examiner doesn't understand the invention much, or maybe the inventor or applicant wants to clarify certain things with the examiner. So even in India there is a hearing procedure. In the US there is an examiner interview procedure. So that is an optional step that can happen. And then a response to office action is filed. Once a office action is filed, examiner reviews it again. If he's satisfied, he will grant it. If not, an office action is received. So the loop continues. Now this iteration can continue, can happen 2 to 4 times. It's a ballpark range both for India and US. In India, we have a set period of 1 year to close the prosecution. Usually 2 to 3 iterations happen. Similarly, in the US, it's usually every block of 2 sets. It's in prosecution happens in blocks of 2 iterations. But what we generally see is it takes about 2 to 4 iterations even in the US. Now, what is important here is in terms of strategy of ensuring that the best possible claim is allowed at the end when a patent is granted, is the general strategy has been that okay, you start with a broad claim because we want a broad claim, and therefore, and then let the examiner figure out what the prior art is. And then if he finds the best prior art, he will send it, and then we will review it, and we send the response to office action saying that, okay, we think the prior art is not relevant because of reasons A, B, and C. So it's a kind of a negotiation process that happens between the applicant and the examiner. The applicant is trying to be greedy by writing very broad claims, and the examiner is trying to narrow the claims such that the claims don't read onto prior art. So the examiner's goal is to ensure that claims don't read onto prior art. The applicant's goal is to keep it as broad as possible. So while they start at different ends, during the process, during these number of iterations, 2 or 3 or 4, they both kind of converge together and meet somewhere in the middle. So it's a kind of a negotiation process where both lose a little bit of ground, but in the end, they meet their goals to the extent that is possible under the legal system. So that is what generally happens. And the approach most of the cases go through is start with a very broad claim, leave the responsibility of finding the relevant prior art to the examiner, because it's very difficult to find relevant prior art given the time constraints that examiners themselves have. So leave it to the examiner. The examiner will figure out the prior art, and then we will argue and ensure that we get to some middle ground. So that is a strategy that works most of the times. We have also done that many times. Next slide, please. All right. So we've also done that many times. Now, so just to illustrate that example, I will show you through an actual independent claim in the form of an independent claim. So this is a method of, say, eliminating duplicate records in a database, or you can even think of it as eliminating duplicate rows in an Excel. Let us say that you have a list of names in an Excel sheet. How do you eliminate duplicate names from the Excel sheet? So this is a method of doing that. Our goal was to, when we started, the invention is about how do you normalize individual fields. The fields could be, for example, first name, last name, or an email, for example. How do you normalize individual fields so that all the records are comparable to each other in terms of, the similarity? So although the invention is actually in normalizing, we don't actually provide all the details of normalizing in the independent claim when it was initially filed. So for example, if you see this first step, normalizing records using a knowledge base. So according to the inventor, the main invention is, okay, he has a knowledge base, and that knowledge base is used to figure out relevant information between names and emails. For example, if email ID is first name.last name@company.com, and first name, and in the record first name is there, but last name is missing, what normalizing does is it reads that, okay, there is a last name in the email ID, but then there is no last name in the last name field, so I will take that information from email ID and then fill it. So that kind of a thing. So it basically normalizes, fills and does all that stuff, and then ensures that all the records are on a similar level so that records can be compared. Now, all that information is not revealed. The logic to do that is not revealed in this claim. Purely, just broadly normalizing is mentioned, and then other steps are mentioned. So this is an example of starting a claim at a broad level without actually revealing a lot of information or the exact novelty within the independent claim. I'm assuming that you guys know that independent claim is what is the first claim in a claim set, and therefore it defines the scope of the invention that is being claimed at a broader level. Next slide, please. Now let's see what happens when it goes through an office action procedure. This is a case where initial prior art search, initial prior art search was done, but then no prior art was revealed. In terms of the applicant was probably did a Google patent search or something like that on his own, but he did not do any rigorous patent search. And then he came to us and said, okay, this is an invention, I just want to file it, and I want to get the broadest patent possible. I don't want to get a very narrow patent. So when we file it, we're not revealing a lot of prior art to the examiner, and we are placing the burden of finding relevant prior art on the examiner. The examiner will, found out some references that talk about, comparing two documents and then normalizing information and then removing duplicate information. So, okay, so then based on that prior art, then we said, no, that is for unstructured text because those are for open documents. This invention is about structured data because this is for things like records in an Excel or records in a database. So then we added a limitation in the next office action saying, okay, this is for eliminating duplicates from structured database, not unstructured. Okay, so based on the prior art that the examiner comes up with, then we'll keep adding limitations to the minimum extent possible so that we keep the claim as broad as possible. So this is one limitation that we added in the first office action. Next slide, please. Now, after that, the examiner came back and said, okay, there are some references that are talking about not exactly the same method, but something similar that are talking about structured records. And therefore, I think it may be possible for an ordinary person in the art to combine those references and do what you're doing. Then we said, okay, fine. If you think structured records can be done that way, we don't agree. We argued. We went back and forth, but in the end we said, okay, we are happy to get the patent granted for just for contact records because the invention is about eliminating duplicates from records of in a contact database. So then we added the limitation of contact records in the independent claim. So this is what happened in the second office action. Next slide, please. Then the examiner went back and he found some more references regarding normalizing and all that stuff. He said, "Hey, now I found references, and therefore I think if you guys add something relating to normalizing within the independent claim, then I may be able to allow the case." Then we went ahead and added the limitations regarding normalizing steps. Then this case got allowed. So if you see, we started a very broad. We started the independent claim at a very broad level, and then depending on the prior art references that the examiner brought out, we narrowed it down little bit by little bit, and then we found a middle ground where the examiner and we agreed that okay, this is the level at which we should close. So this is a common strategy. This is nothing unique, but then you really need to understand where to start in terms of the breadth of the claim. Sometimes if you start too broad, it may take too many iterations. For example, this one took 3 iterations. Sometimes it may take too many iterations. So are you willing to go that far? So those are the kind of strategic choices that we make. Now, at the end, if you do this, yes, you get a patent. But the question is, can you go to the next slide, please? So the question is, will that work? Previous slide, please. Yeah. The question is, will that work every single time? The answer is no. You don't necessarily follow that strategy and end up with what you want all the time. So let me take you through another example and then try to put all this in a framework for you to understand. Okay, what are the various constraints, choices, and therefore what are the strategic choices that we have to make to ensure that a patent remains strong even after going through this process. So this is another example where a similar strategy was followed. This is something that I picked up from the internet, where there is an invention about searching on search engines like Google for certain specific information. Let us say a particular type of document like resume. A lot of people don't know advanced search mechanisms on Google. Typically 99% of the people go type in the box that is there on Google search page, and that's it. We don't really limit. We don't limit by title keywords, or we don't limit by age, or we don't limit by a lot of advanced features that are provided by Google. So this invention is about enabling domain-specific searching by using automated scripts. So the intention of the inventor was to cover the process of searching automatically using scripts. So the initial claim was only talking about that process of how the script is defined and script is used to search. Now go to the next slide, please. So this is the final form of independent claim, where additional limitations were added regarding a marketplace for selling these search scripts. Click once, Akshita. Can you please click once? Yeah. So if you see the first set of the 3 or 4 elements were focusing on script definition. Click once more. And then the second part was talking about marketplace. Now the goal of the inventor was to capture script, but then ultimately script definition and marketplace both got mingled up into a single claim. Now the reason is that it was probably detected that there was more novelty in the marketplace part of the invention rather than the script definition part of the invention. If the inventor had known earlier that marketplace part of the invention was probably had more novelty, maybe he would have made a informed choice that, okay, let me focus on an independent claim that is that is directed at the marketplace side of the technology rather than the script definition side of it. Maybe he would have gotten a more better purchase by having a better claim where it was only focused on marketplace rather than combining both. Now it could still be done during the prosecution process where they could add another claim only relating to marketplace, but then that only extends the procedure. It drags the case a little more, which means it costs a lot more to get it to the end. So starting always at a place where you think the invention is doesn't necessarily get you the claim that you want, or doesn't necessarily get you the kind of protection you want. Now with this kind of claim, if somebody has to, if the inventor were to enforce, the infringing party has to be in both parts of the invention, which is script definition and marketplace. So so that is a very narrow claim, and it did not solve the purpose that the inventor started with, which is to protect the script definition side of the invention. So things like that happen. So my point is, I showed one example where it started out broadly, everything was beautiful, everything fell in place, and then the negotiation happened perfect, and the inventor, the applicant, got what he wanted. In the next example, it started out very broadly. Again, the inventor was greedy, but then it did not go in the direction that he anticipated. So starting broadly at where you think the invention is doesn't necessarily solve the problem for you. Next slide, please. Yeah. So you'll have to. There are constraints in the process. Every choice that you make, there could be a positive effect, negative effect. These are the 4 main elements that I picked up in delineating this whole process. One, whether to do prior art research or not, and whether to reveal the prior art references in your patent document or not. That has a significant bearing on the quality of a patent and also on the prosecution process. It definitely increases doing a detailed prior art research and including the references in the patent document. It definitely increases your chance of avoiding prior art because you know exactly what prior art is there, and therefore you will start at the right place in terms of definition of the claims. However, it may also limit your ability to write broad claims because now you're aware of a lot of prior art, and you may end up writing very specific claims. And that's the reason why a lot of practitioners just start at a very broad level. So that's one thing. Now, broad initial claim, is it always good? Yeah, a broad initial claim may increase chances of grant, but then it could also lead to more office actions. If you start at a very broad level, you will be getting into more iterations. It could be even 5, 6, 7, 8 iterations before you get convergence happens between the applicant and the inventor. And like I showed, sometimes you may end up with unintended claims because many times for an average patent, when a patent goes through 3 or 4 iterations, the inventor or applicant is tired He doesn't want to spend that money anymore to ensure that he gets his right claims. When they start the process, it's all rosy. They want to get a patent. They're all excited, but it can be a very tiring process. Getting a patent can be a tiring process sometimes. So you end up with unintended claims. You just want to close the case and get a patent, and then deal with or figure out what to do with that patent later on. So that could be a negative side effect of starting with a very broad initial claim. Now, more office actions are sometimes considered good for the quality of a patent or strength of a patent, because it would have gone through more scrutiny by the patent office, and therefore there are lesser loopholes in that protection. But then more office actions can also lead to very narrow claims. So these are the kind of things that you have to keep in mind in defining the scope of the claim to start with. You'll have to consider whether you have to do prior art research or not, whether you have to start at a level that is very high in terms of the breadth of the claim, or at the level that is optimum for you. So in order to make those decisions, you need to have your strategy clear. Do you want to get a patent just to protect your invention, or do you want to get a patent so that you can actually enforce your rights on others? So depending on your strategy, whether you have an aggressive strategy or whether you have a more passive strategy, these kind of choices will be made depending on those. But there is no one clear cut answer saying, okay, this is the approach that needs to be followed. For everything, there is a positive effect, negative effect. There are pros and there are cons, and that's a choice that you have to make, which means you have to have the strategy very clear. Next slide, please. So I don't want to leave you at a place where I've confused you. That's not my goal. My goal is to say that there are certain things that will increase the strength just procedurally. So that is what I wanted to show through the two examples, that procedurally, if you do certain things right, you could ensure that the patent goes in the direction that you want it to go, and that it has gone through the level of scrutiny that gives it the quality that you want. So one thing that you can ensure from a technical standpoint is review as much prior art as possible. If you review as much prior art as possible, you will know for an average patent, it can cost tens of thousands of dollars to get a patent protection. You want to ensure that you know what are the chances of getting the patent before actually getting into the process. But for that, it's very useful to review as much prior art as possible. So reviewing more prior art also gives you a better understanding of how to define the claims. Okay, that's one thing. Now the second thing is breadth of claims. Breadth of claims is very important. When a claim becomes too narrow, typically this is a ballpark that is used in regression analysis, in a general statistical analysis of patent portfolios, which is if a claim is more than 500 words, it's probably not worth looking at it. If a claim is less than 100 words, it's probably worth looking at it. So that's a very crude way of, because it's run over in hundreds and thousands of patents. We need certain metric, but there is no sanctity to 100 and 500 as words. I mean, it could be 200 and it could be 400. So, but the point is, if the claim is very long, it's probably because it's too narrow and there are too many elements in it, and it's probably because and it becomes very difficult to enforce such a patent on somebody else. And there's more scope for a competitor to kind of avoid that claim because there are more elements. Even if he doesn't do one of those steps, then he will not be infringing. So that will give you a good assessment of, okay, if the independent claim is too narrow, then you can sit back and say, okay, whether is it worthwhile for me to take this patent or not? Is this patent going to be strong? If so, if I have to file this, why do I have to file this? What are the reasons why? You may well have a very good reason that you just want to protect what the invention that you're putting out in the market, but all I am saying is that gives you an indication so that you can actually make an informed choice as to why you're going for that patent. The third point is prosecution history. Many times in India, what we see is, clients and customers come to us and say, hey, that particular company is getting a patent in like no time. Yeah, sure. I mean, in India, a lot of things can happen without any review. But the thing is, if you really want a strong patent, you better ensure that that patent application goes through a thorough review through the examination procedure. If it has not gone through a thorough review of examination procedure, it will probably not stand in the test of court in a court of law. So it's always better that a case has gone through tougher scrutiny. The more officer action it has gone through, it means that it has been scrutinized more. It means that it has been, it has lesser loopholes in terms of, getting a grant. So, prosecution history is always a good measure. Does it mean prosecution is always good? Well, you may not get what you want, but at least whatever you got will stand the test of time. That's what it means. So technically, I would say these are the three main aspects that you need to look into in terms of how a patent is evolving. Next slide, please. And there are certain aspects that are commercial in nature. Those are also things that, as an applicant or an inventor or an in-house counsel, you need to look at, which is the stage of development of technology. If the stage of development of technology if the technology is just being developed and and a patent is being filed, probably the invention is redefining the field or starting a new field, and therefore the chances of it becoming a strong patent is very high, because probably more people will use this technology to develop, and therefore this becomes a fundamental patent. If the stage of development is very late, in the sense that there's a lot of prior art already existing, and the invention is about changing a small portion of the technology that is already existing, then it's probably an incremental technology. So that gives you, so what I'm saying is, a prior art will give you a good understanding of the stage of development of the technology, and based on the prior art, you can make an assessment whether it's going to be a redefining kind of a patent or an incremental kind of a patent, and then make an informed decision as to whether that is useful in your portfolio or not. So the other commercial aspects, a patent adds more value if it covers the way product is transacted. Many times practitioners can go into a cookie cut mode. Okay, write a method claim, write a system claim, write a method claim, write a system claim. But the point is, if a company is making chips, integrated circuits, and if they're selling integrated circuits directly without putting them in a system, then they better have claims that are directed to integrated circuits rather than the entire system. So it's what kind of claims that we write should be driven by what the company or what the applicant does in the market. It's many times practitioners can get into a cookie cut mode, and that such mistakes can happen. So it's important to look at, okay, this is my product, and these are the claims. Do they actually map onto one another? And do my claims actually read onto the product that I'm selling in the market, rather than the final product where this may go and integrate? So that is very important. So a product to patent mapping is very important, and having that information at hand gives you another tool to say, okay, this patent actually maps onto this product, and therefore this is useful for my portfolio. So that's one thing. Another is the bargaining power. Many times, as I said earlier, sometimes individual patent may not be valuable at all. It could be just a very small incremental patent. But then if you're a company that has thousands of portfolio and you need thousands more to be able to negotiate with other companies of that size, then any patent may be valuable for you. But that's not the case for the average patent in the market. And for the average patent in the market, we better ensure that there's not much prior art, or even if there is much prior art, we have thoroughly reviewed the prior art, and that the claims don't read out any of those prior art. So the fourth point that I wanted to talk about is the existence of alternatives. If a technology is of such nature that there are lots of alternatives to achieve a single function, which is what is software is. You write a functionality in software, it's probably the same functionality can be written in zillion different ways, using different languages and different platforms. So it's really difficult to protect just the functionality in software, for example. So if the technology nature is such that there are lots of alternatives available to achieve a functionality, then the value that patent brings to you is minimal. Now that's again a scenario where you have to think about and make an informed decision. I'm not saying those are not valuable and therefore don't file it. All I'm saying is these are the things that you can use. These flag points, what I call them, that you can use to kind of review and say, okay, this is the reason why I'm filing. Many times applicants or inventors may not critically review and may not actually make an informed decision as to, okay, and may not even know why they filed a particular patent at that point in time. So all I'm saying is there are certain checkpoints that you can do, and based on the checkpoints you can say, okay, this is the reason why I need to file, or this is the reason I don't need to file. So those are the checkpoints that I think may be useful for you to these are the checkpoints that I think that may be useful for you to do that. Next slide, please. So putting it all together, is there any one overarching thing that I can give you to drive this whole the quality of patent thing, both from a technical standpoint and from a commercial standpoint? There's one thought that I can leave you with. Click once, Akshita. Which is identifying the problem that you're solving. This is one of the most difficult aspects of writing a patent application and getting a patent granted. If you solve this problem well, then entire thing will fall in place properly. Many times I see wrong claims being written, or wrong definition being made, or wrong scope being defined because the right problem is not addressed. Many times inventors are so engrossed in their own technology that they're not able to see the forest for the trees that they're involved in. So patent practitioners sometimes can be better at it because they're not really involved in the technology so much, so they can see the forest. They can say, hey, this is the problem that you're solving. They can put it in a framework saying, okay, at this level, if you define the invention at this level of problem, then you will not be reading onto prior art, and therefore you may get into get the protection that you're seeking for, even after going through a rigorous prosecution process. So identifying the right problem and then deconstructing that. Click once more, Akshita. So identifying the right problem. Once more, please. Once more. Yeah. So identifying the right problem is, for me, the most important thing. Many times I see applicants and inventors using patent agents and patent practitioners as transcribers, but you should be using their time in ensuring that the right problem is addressed through the claims and the description and the other sections. Once that is done, everything else will fall in place, trust me. So to be able to identify the right problem, you need to first understand the relevant prior art, and you need to understand the legal and the examination procedures, which is what I was trying to address. With the knowledge that, okay, a patent application will go through this kind of a negotiation process, you can make an informed decision as to, okay, given that I'm going to go through this negotiation process, where do I need to start, and at what level do I need to define the problem so that I'm willing to give a little bit during the process. All right. Well, hopefully this was useful. My colleague will address the post-grant process, where we will talk about how to review an existing portfolio explicitly to ensure that we find out the patterns that are not useful and we find the patterns that are useful, and therefore make key decisions based on whatever strategy that we follow, whether it's an aggressive strategy or whether it's a passive strategy. Over to you, Sendil.
Yep. Hi, this is Senthil. Am I audible to you?
Yeah, go ahead. Go ahead.
Yeah. Yeah. Arun explained about basics about patents. I'm going to take through the post-grant essentials. If you have a patent portfolio, it is not easy task to find out which is strong patent and which is the weak patent if you have a good portfolio. So here we are providing a value to each patent in the portfolio based on the few parameters that I'm going to take you in the next few slides. And normalizing the overall value will give you the insight about how strong is your patent. There are typically two type of analysis. One we can consider non-technical based evaluation, which may be considered simple analysis. Another one technical based evaluation, which may be considered in-depth analysis. Usually that in-depth analysis will take more time compared to the non-technical based evaluation, which is simple analysis. So in this slide, we are going to see what are the non-technical evaluation, what are the parameters for non-technical evaluation. So first parameter is status of the patent. It plays the major role while deciding how strength is your invention. If it is whether it is application or granted patent. Granted patent will give more value compared to the application since it is scrutinized by the examiner and got granted. So granted will be having more value compared to the published patent application. Second one is age of the patent. So here the way I look at it is how many times the patent is a particular patent in the portfolio is kept in force more years means which is having more value compared to the other patents. Otherwise, in other words, we can say how long the patent has been kept in force by paying the maintenance fee, which may be considered as more value compared to the other patents in that portfolio. Third parameter is number of continuations. If the continuation of the continuation in part of the particular patent application is more, which means the particular applicant is trying to cover all aspects of the invention. So it adds more value compared to the other patents which doesn't have the continuation or continuation in part. Next parameter is number of office actions. If the number of office action is more means which the patent has been testified by so many prior arts, so it adds more value compared to the patents which has less number of office actions. Then next is whether if there is a patent which has been used for litigation, that is infringement suit, which may be considered as stronger patent compared to the rest of the one. Then whether the particular patent, if there is a patent which is reissued or re-examined, which may be considered as strong patent because it has been again examined by the patent examiner. So you have that patent is again testified by so many prior arts. Then next parameter is the number of forward citation. If a particular patent in your portfolio is being cited by the in the forward citation of other patents, if it is keep on increasing, which means that patent value is maybe considered more compared to the other patents in that particular portfolio. Then family size also makes the difference. if a particular patent in your portfolio is being covered in many countries, which may be considered as which means the applicant wants to cover this invention in more number of countries. So it may be it will add more value. Then number of independent claims. If the number of independent claims is more means for the particular patent, which means the patent has been covered in all aspects of the possible embodiments of the invention. So we can give more weightage if the particular patent in the portfolio has more number of independent claims. Then number of patents cited by examiner. During the office section or examination process, if no more number of patents has been identified by the examiner for a particular patent, which means it may be considered as less value. So here I have listed out 10 parameters. It is not necessary that we have to give equal weightage for all the 10 parameters. We can select few parameters, for example, that number of independent claims, whether the particular patent is litigated, will be giving more weightage compared to the rest of the parameters. We can decide while analyzing the portfolio what are the parameters should be considered to while identifying the strong and weak patents. In this slide, we are going to see the second type of evaluation, which is technical, which may be considered in-depth analysis. This in-depth analysis may be taking more time compared to the non-technical evaluation. So here I have listed a few parameters. We will go through it one by one. Limitation in the preamble of independent claims. If there is a limitation, then which means it is you are narrowing down the scope of the application for the patent. So which is reducing, which cannot be used if someone is using some other application. Let's say the invention is about on mobile application. So you have put the if restriction like cell phone application, then if someone is using other than cell phone application, you can't stop them. So limitation in the preamble also plays the major role while deciding the how strong the patent is. The second one is limiting words in the claim set. In the claim language, especially in the independent claims, we have to try to avoid wherever the limitation word such as comprises, wherein, whereby. It is always not possible to avoid these kind of words, but we have to make sure that whether you are giving the protection, you are covering broad range of applications without restricting particular application. So that if someone is using that without particular component or particular element, you can't stop them to manufacture. Third one is change in claims from application to grant. If there is a change in the between the application and the granted patent, then that may be considered weightage will be more, so which may be considered weak patent in the particular portfolio. The fourth parameter is product or method claims. So you know that the claim will be protected by a lot of claims, that product claim as well as method claim. So here method claim has more value compared to the product claim because method is covering the functional aspect of the invention. So which may be considered which has the which gives you the broad protection compared to the product claim. So while giving the weightage, we can decide which parameter should be considered, which parameter should be given more weightage compared to the other parameters. By normalizing the overall value, then we can you will get an insight which patent may be considered strong and which is weak patent in your portfolio. Here in this slide, we are going to see how to find out the patent strategy, right patent strategy for you. This broadly we can consider two type of approach. One is the defensive patent portfolio, another one is offensive patent portfolio. In defensive patent portfolio, you have the patents as well as you have the products, so which is in line with your core business products, which means you have what the products which you have is adequately protected by your patents. So this how to identify these things? This can be done by doing the patent to product mapping. So by doing the patent to product mapping, you can come to know what all the patents are, what all the products are covered by your patents, as well as it will give you insight what are the underutilized patents, which means non-profitable patents. Then you can take a decision what we can do those underutilized, how to commercialize those underutilized patents. The second strategy is offensive patent portfolio. Offensive patent portfolio is you have the patents, whereas your competitor or third party has the products. So this is also you can do the, how do you know that whether the competitor is infringing or you or not? This can be done by doing the patent to products or go ahead for we can commercialize those patents by filing an infringement suit. So once you file that infringement suit, your patent may be product company. So in order to be safe side, you have to make sure that the patent is really valid, or in other words, how strong is your claims. Once you start filing infringement suit, this may be validated or challenged by the competitor. That the third one is if the patents are interrelated. There is one more option is you can monetize those patents by doing the cross-licensing with your competitors or third parties. You have few patents, your competitor has few patents which are interrelated. Then by doing the cross-licensing, you can make a better product so that both parties will be benefited. This is another option to monetize your patents. In this slide, we are going to see what would be the high level patent to product mapping, what is the process, as well as how will be the report. So first I will take you through the patent to product mapping high level. Yeah, this is how the report will be for the patent to product mapping at the high level. Here we can see that, for example, in the fourth row, I have given the feature. Let's assume that this feature, your competitor has this feature. So this is claim analysis. This patent I have referenced, I have given one publication, which let's assume that this is your patent and this is your product. In the next sheet, I have compared with the patent application claims as well as products. On the left hand side, you can see this. I have taken the example of one independent claim. um, uh, I have breakdown into elements. Each cell has each elements of the particular independent claim. So whether all these independent claim are reading on, or overall it is mapping with the accused product or not. So this is a high level patent to product mapping. Then next is patent to product mapping, which is detail level. Here I have taken the same example. Left hand side is the independent claim elements of the patent. Right hand side is the accused product. It may be your product, or if you want to sue, then it will be competitors' products. Whether all the elements of all the independent claim elements of the patent is mapping with the product or not. This is the objective of this P2P mapping detailed analysis. Then once you, if it is mapped here, once it is, you come to know all the elements are mapping, then you can say this may be that particular product is infringing particular patent. Once you decide that, as I said in the earlier slide, you can monetize by filing an infringement suit. So once you file an infringement suit, the validity of the patent will be challenged by the competitor. So in order to safer side, you have to make sure that the patent is really valid. For that we have to go for a validity check of the claims. The third one, I have given the sample report of the validity search. Yeah, sample report of the validity search will be like this. We have to take the patent which is to be validated, or we have to make sure that this patent is really valid before filing a infringement suit. In this, on the left hand side, we have in the validity search, we have to make sure the patent claims are really valid. Here we'll be giving more importance to the independent claim elements. Once the independent claim elements are valid, then we'll be giving focus more into independent claim elements. On the left hand side, I have breakdown into all the elements of the one independent claim. Then right hand side is the prior art. So here we have to take the prior art. You may have a question like this patent is already granted or examined and granted by the examiner. So what is the point of going for validity check? So even there is a possibility that some close prior art may be missed by the patent examiner. This is because of the time constraints. They will be reviewing the lot of patent examiner will be reviewing lot of patent applications. So they have limited time to find out the prior art. So here we have to uncover the prior art which was missed during the prosecution. By uncovering the prior art which was missed by the patent examiner, we can check whether the claims are really valid or not. So in this report, left hand side is the elements of the particular patent and right hand side is the prior art. By doing this comparison, we can come to know how strong is your claims. That's it. That's the end of this presentation. So if you have any queries, please raise your hand or type your questions. Arun, you want to add something?
Yeah. Yeah. So I think a couple of things that I'd like to kind of add to what Sendil was saying. So the parameters we just gave an overview, and depending on the reason for doing a portfolio analysis, the role of parameters may change. And as Sendil pointed out, not all parameters are equally important. So Sendil's team actually, in doing a portfolio analysis and in comparison between portfolios, we actually do a regression analysis, and so some of the parameters may actually get dropped in certain cases because they don't, significantly add to the value that that we get out of the whole regression process, which is to understand similarity between two different portfolios. So, but in general, the parameters for an average pattern, whatever Sendil explained makes sense. There may be patterns that are defining a new space, and some of the things that we say may not make sense for them. So the strategy has to be changed. Other than that, but for most patterns, probably 98-99% of the patterns, the parameters, the explanation that Sendil gave applies. So we have to take them, with a pinch of salt, because the role of parameters and how actually we look at them may change, and some of the parameters are interrelated. They're not like independent variables. So with that said, I'll leave it to the floor open for questions, and we'll be happy to answer any of them.
Thank you, Arun. Thank you, Senthil. Now there are a couple of questions. The first question is from Srividya. What is the difference between continuation and continuation in part?
So both are continuation applications in general. Continuation application is something where you are covering a material that is already there in the existing application. So for example, you file application A. Usually you file continuations because there is a restriction requirement, which means the patent office believes that, or the patent examiner believes that you have two different or multiple inventions that are covered in the same application, and therefore he wants you to choose only one invention, and the rest of the inventions must be covered in subsequent continuation applications. So continuation application, there is no new material being added. You are basically covering what was originally disclosed in a new application. So this new continuation application will have the same priority date. All the claims will have the same priority date. Continuation is, in part, is as the name suggests, it's only partly continuation, partly new material. So you actually introduce new material. When you want to introduce new material that was not there in the original application, then you file a continuation in part. So as the name suggests, many times only part of the claims will get priority date to the extent that they were covered in the original application, and part of the claims that are based on new material will not get the priority date of the original application. They will get the new priority date based on the application date of the continuation in part. So that's the fundamental difference between the two.
Okay. She has asked for another answer also. Like in case of drug molecules product, patent takes more value than the method. There can be many methods of preparing the molecule. So ideally, product will have more value. What is your opinion?
Correct. Yes, so that changes depending on the technology and all that stuff. So again, as I said, we have to take it with a pinch of salt. We're talking about on an average for most patents. There are certain technologies where product has more value, especially with respect to molecules and so on. So yes, it changes depending on the domain.
Okay. Next question is age of patent. Here in age of the patent is more, it is given a higher value. Is that true?
Yeah, I mean, it depends on what you're looking at. If you know for sure that the patent, say, laser technology and it's the first patent on laser technology, then, more years that patent has, it probably has more value. But we are talking about, for an average patent, an average patent, we will know it is valuable when people are actually spending money to maintain that patent. If people are not spending money to maintain that patent, it probably means that patent is not that valuable. So when Sendil explained, he he kept in mind an average patent. He's not keeping in mind a blockbuster patent. For a blockbuster patent, if it has more years left, then it's probably more valuable. So what we are looking at here is not ascertaining value of a patent, but ascertaining picking out points that you can use to make decision on, okay, is my portfolio working for me or not? So that kind of a thing. So from that perspective, we took an average patent as a reference, and that's why that. So there may be other scenarios where portfolio is a defining portfolio, so we will change the parameters when we assign values to them. So that's why I said it's not cut and dry. It's not one single approach. Just to keep it simple for the presentation, we gave one particular view. When we actually do the rating and ranking of portfolios, it's a much more complex process. It's not even straightforward. One parameter is, there are certain parameters like office action and claims and length. They're very interdependent. So, all that is taken care when we do it.
Okay. Next question is, how different is registering patent in India compared at global level, and also differences between patent registration to utility registration?
How difficult or how
No,
different?
different. How different is registering patent in India when it is compared to global level, like some other countries? And also difference between patent registration.
Well, I can take to patent registrations too?
Utility registration.
Utility, okay. So answering your first question, I will take a comparative example between, say, India and US. It's not very different in the sense that India doesn't provide them. The certain differences are there, but broadly they are the same. As I said, the process is similar. The certain differences are there. The differences are that in India it takes longer to get a patent. In US, for example, it takes shorter. In most developed countries, it takes shorter than compared to India. So that's one. And then two, India, the prosecution process is limited to 1 year. Only 1 year is given once the first examination report is provided. Whereas in US, there is no such limitation. As long as the applicant, wants to continue, he can keep continuing by paying additional fee to examine the case. So these are the two fundamental differences. There are differences with respect to specific subject matter. For example, software. It's difficult to get a patent in India, but it's much easier to get a patent for software-related subject matter in the U.S. And Europe has a slightly different view. Even in Europe, software is it's easier compared to India, but then more difficult compared to U.S. So there are certain nuances that are there, but broadly the process is similar, across the countries except for the timelines. So that's one thing. Addressing your second question of patent versus utility, I mean, generally what we call patent is basically when we refer to the utility patents. So you probably are talking about design patents versus utility patents. Different countries treat it differently. For example, U.S. It's also considered a patent. In India, I mean, our law, we have a separate law for industrial designs. We don't even call them patents. We call them, technically we call them industrial designs. So to that extent, there are differences, but in terms of similarities, it's both are easy to get, and there is not much scrutiny in getting a design patent in the U.S. Similarly, in India too. So I think to that extent, they are similar. But from a legal point of view, in India, technically, it's not a patent. It has a different law. So to that extent, they are different. Hopefully, I answered the question.
Yeah. Next question is, what is the difference between patent to product mapping and FTO, freedom to operate?
Well, so patent to product is basically to understand whether your portfolio is working for your, for your products or for the business goals or not. Especially when you do an internal review. When you do a competitive review, then it's more for a strategic purpose, whether and to make a decision on whether to go against a particular competitor, either for licensing or for an infringement suit, and so on and so forth. Whereas an FTO is more, that is the context in which we talked about patent to product mapping, because remember, this session is about understanding the strength of your patent and whether it's adding value to your overall business goals. And therefore, we want to ensure that patents are actually mapping to products first. That's a basic requirement, right? So that was the context in which we were talking about patent to product. FTO is more of, it's not about your internal product. FTO is more of your product mapping onto existing patents. So that's more like an infringement analysis when we do FTO. Here it's more like, okay, whether in the patent product mapping that we are talking about, we are more talking about, okay, which patent cover which concepts in our products, and therefore two questions are answered. One, is there any patent that doesn't map onto any product, which means that's a useless patent at a very basic level if you have a very passive patent strategy. So that will be one question that will be answered. Second side is from a product side. Is there any product that is not covered by a patent? So both sides you will be able to answer a question and then align your patent portfolio with respect to your product portfolio. So that was the context in which we were talking about patent products. So the goals of both the FTO and patent product mapping are very, very different, especially in this context.
Okay. Next question is, what is the difference between validity search and invalidity search? He has asked for brief explanation.
Well, it's a coin, but two different sides. You can look at it from any which side. If a patent is valid, then you couldn't invalidate it. If a patent is not valid, then you could successfully invalidate it. So validity or invalidity, that's why you see a lot of times people saying validity or invalidity, because you will achieve both. So it depends on the goal that you're looking at. If you are the guy who's trying to sue somebody else, so before suing you want to ensure that your patents are valid, so you go and ask somebody to do a validity check. Now if you are the guy who's sued, then you want to invalidate the patent of the guy who's suing you, and therefore you go to a patent practitioner and say, hey, I want to invalidate that patent. The study and the analysis is the same. It's just the goal is different. The goal with which you start changes the name of the project, but what exactly happens in the searching and analysis is exactly the same. It's just like two different sides of the same coin. Hello? Akshita, can you hear me?
Yes, yeah, I can hear you. Okay. Next question is difference between Swiss type use claim format and purpose bound product claim. What is the difference between? He meant to say, what is the difference between Swiss type claim and purpose bound claim? If I'm not wrong, yeah.
Oh yeah, this is an elaborate question. I think this is out of scope, but what we'll do is we'll send a detailed response to them.
Okay.
Yeah, we'll send a detailed response to them.
Yeah, sure, we'll do that. I'll just read out a few more which is relevant. After a patent is granted, what could be the solution if the patent is few years down the line, proves to be worthless in terms of monetary benefits?
The solution is dependent on the strategy. If it is an organization and it has a portfolio of patents, then we need to see if it fits in the portfolio and whether that can be that adds value as a portfolio, whether it adds value as a single patent or not. If you are an individual inventor or a small company and if you file for a patent and it's not adding value, then it's probably the right time to try and sell it. If you cannot sell it, then it's probably right time to basically abandon it by not maintaining it. But if I have to give one answer, then it's probably time to sell it by looking for a buyer.
Okay. Next question is, what about priority date of continuation in part applications? And he has asked to elaborate specifically about new materials added.
Yeah, any new material added, for example, let us say that I came up with a new type of fan that has aerodynamic blades. and so that's the original application, and to that maybe I add a bulb later to that. For example, I add a bulb to the fan, and let us say that's going as a continuation in part. It's a silly example, but let's just consider that that's the context. Now, the continuation in part that has a light, and any claims that focus on the light aspect of the fan, will not get the original, priority date, whatever is the priority date of the original application. Now, any claims that are directed to the aerodynamic aspect of the blades of the fan, which was the original invention, will still get the priority date of the original application. So, certain claims can have certain priority date, and some other claims can have different priority date. So that is how it works.
Okay.
I hope. Yeah.
Yeah, there are lots of questions. I'm just selecting the more appropriate one. I think we can write them personally later because the questions are really long and we can detailedly discuss later. So I'll just pick this question. What should be the strategy in case if applicant want to change elected species in restriction requirement later or during prosecution in US?
Well, once you're elected, I think you're pretty much stuck with it. You cannot change what you elected as an invention because the inventor would have gone, the examiner would have gone ahead and spent time on it. So it's pretty much like any other service provider. You're paid some money, and they're doing a service for that particular fee that you paid. So once they take up an invention as an invention, the rest of the claims are not relevant to that case anymore, unless you file a follow-up application in form of a continuation application or a divisional application. So that's pretty much it. Once you elected and once the examination process starts, I don't think there is any other recourse for choosing another set. You need to file another application for the rest of the claims to have them examined.
Okay, I'll pick another question. How many independent claims are allowed in each patent application?
Well, theoretically unlimited. I mean, depends on how much money one can spend. From a legal point of view, as long as the independent claims are related to one inventive concept, the number of independent claims itself is not restricted. Famously, we know of a case that has 867 claims, and there are lots of independent claims in that set in one single patent. I don't even know how many, but theoretically there is no limit to how many independent claims one patent can have. As long as they are related to one inventive concept, they can remain in that.
Okay. Next is how to develop a strong patent portfolio for biotechnology-based patent applications.
Well, the concept is similar. There's nothing, I mean, we use simple business method examples because we know people from different fields come. There's some people from mechanical domain, some people from electronics, some people from biosciences. So we will not be able to do justification for everybody if we use, very specific, domain-specific examples. So we use very generic examples. But the concept is very similar. The notions are the same. The checkpoints are the same. The length of claims, for example, is, that applies to, irrespective of technology. The parameters are the same, but how you view the parameters might change a little bit. So the entire process is similar. There is no, it's not markedly different between high-tech or between biosciences related inventions, except that certain things like how one participant pointed out that method versus product, things might change. Rest of it remains the same. So there's fundamentally there is no difference between domains in terms of portfolio analysis or in terms of looking at the patent procedure to ensure that right claims are awarded and so on.
Okay. Next question is what value do the dependent claims have in claim analysis with respect to independent claim? I think Senthil would like to answer this question.
Hello?
Is it in the context of portfolio analysis?
Yeah.
Yeah, go ahead, Sendil.
Yeah, I will read out the questions. What value will
Dependent claims having claim analysis with respect to independent.
Yeah, dependent claims or once the independent claims are invalid, even by default, all dependent claims are not valid. But in vice versa, it is not possible in the vice versa. Even the independent claims are few times it happens that independent claims are valid, whereas the dependent claims may be invalid with respect to the prior art.
Yeah, that's true. In general, what happens is during examination procedure, examiners they tend to award or grant most of the dependent claims once an independent claim is determined as passing the requirements of novelty and inventive step. Because it's cumbersome, it's very rare that I would not say rare, but the percentage of cases where examiners address dependent claims directly during first office action or second office action is less. So typically it tends to go by the independent claims in terms of analysis. So now when it comes to infringement analysis, obviously independent claims play a lot more role because that independent claim has the broadest definition of the invention. All dependent claims add something more to the independent claim. So if an independent claim, if a product is not infringing on an independent claim, then it means that it cannot infringe on any of the other dependent claims. Because if the broadest claim doesn't capture it, then the narrower claims cannot capture it. So to that extent, that is why a lot of focus, you see a lot of focus on analysis on independent claims rather than on dependent claims, and that's probably is the reason for the question. That is the reason, because independent claim has a broader scope.
Okay. Arun, there are lots of questions. If you want me to read it out, I read it out one by one, or else we can manually type.
So we'll. So what is the time right now? We can.
It's 1 already. 2 minutes to 1.
So we'll take 2 minutes. We'll take the last 2 questions.
Okay, last 2 questions. Okay, this is a question. Though the priority date is different for new material added in continuation in part application, but the expiry date will be calculated as per the earlier date. That is priority. So what are the advantages and disadvantages if I do not add new materials in the same application?
Well, it really depends on the strategy of the company, whether it makes sense to add. It's very context specific. It's very difficult to give a very generic answer. Mm-hmm. Now there may be cases where it is important for you to add a feature along with the existing set of features for protection, either because you have a product in the market like that and therefore you want to ensure that you have it, and probably because that feature independently alone may not make any sense for you in terms of patent protection or in terms of product. Now in that case, you would rather want it to go along with the existing protection rather than try to have not have it at all. So it really depends on the patent, the strategy of the the company in terms of rolling out the technology and having the right protection for that.
Okay. One more question. I think this will be the last question. Why most of the countries will not accept the submission of newly conducted data while the patent in the prosecution stage or examination stage?
Okay, so you have, I think it's, once you start allowing, I think it's a procedural issue. Once you start allowing adding new matter, then there is no limit to when, it gets, when it is stopped. So the right time to stop it is right at the, filing of the application. Once you file it, you have defined your invention. Even so whatever you define as the invention remains as the invention. Now, if you allow once, then which means that it can be done any number of times during the examination procedure, and it becomes every time you add a new material, the examiner has to search for it because it's a new matter and your invention has changed, and it's practically not possible for the examiner to do a search again and again whenever you add new matter. So I think that's why it makes sense to not allow new matter, but you are allowed to make slight changes from a language point of view, or make certain corrections which was originally intended. If the material was originally intended either in the figures or in the description, then you can make slight changes. But I think practically it's impossible to allow a new material to be added to the same application because of that reason. That is why even for claims, if you add a new claim in a new format, the examiner would want to go ahead and search. That will again extend the process. Now, patent office would not like to do search again and again. They would, if they did that, they would charge again and again within a single application, which would not make sense. So, I think that is the reason why.
Okay. That's it, Arun. We'll inbox the other answers or any other detailed discussion later, because we are running out of time. I would end the session now. Thank you for all attendees attending. I sincerely apologize if there is any technical issue or if you went through any technical issue in between. Any questions, any other details required, feel free to write in at contact@ipmetrics.com, or you can write me at akshata@ipmetrics.com. We are available to answer all your queries and questions. Thank you for attending IP Metrics webinar series once again. Thank you.